Are we expecting another member or are we?
I was expecting Liz.
Okay,
She picked up a packet.
okay, we'll give her some time to review. Are we expecting another member or are we? Oh,
Hi. Sorry, I was kind of white knuckling it here.
yeah,
Yeah, between the fog and my road is just still icy in spots.
Yes. Better to be safe than sorry.
Oh,
I guess we're on TV. No. Well, I guess, given that the time is appropriate to start, and we have our members all here, that we can call to order, correct? So I'll call to order the hearing that we're going to have this evening. We do have a quorum, with four of us are in attendance and Russell remotely here. And I'm filling in as like an acting chair just for this one hearing, while Russell is normally the chair. So I'll do my best to try and keep this orderly and running smoothly. And we'll move on with the business. The first thing we have here is there's no adjustments to the agenda. There's just only one hearing this evening. And when the next step here would be the comments to be made by the party who's filed the appeal. So are you the attorney representing?
I am. Yep. My name's
Okay.
Patrick Miller.
I think that podium is live.
Okay.
Isn't that the recording? So if you could go to the podium and present your stuff that you brought and prepared for us.
I will. So first, thanks to the board for your volunteerism. I know that's what makes local communities tick. I grew up in Thomaston. I'm chair of the planning board in Union for about 5 years, and I been in this community for a long time. I'm a volunteer coach at the Madonna Valley High School soccer team, and I practice at Stroughton Pace in Rockland. Tom Daggett is the landowner. He's also a local guy, grew up in Cushing and still lives in Cushing. I bought the property in Waldoboro, I think around 2004. And I think if you don't mind, I think it'd be helpful if Tom described a little bit about the property. I think it'd be very helpful for the board to understand. And we can do that through a narrative, or I can do it through question and answer, whatever you'd prefer.
I think that maybe if he could be near the microphone
Yeah.
and he can be up here with you as you're representing him.
Yeah.
I don't have that problem with that.
Yeah, I was wondering if you had any of these, with a photo, it kind of like would help explain the situation.
Yeah. Well, why don't you go up and start describing from the podium about when you
Okay,
bought it, the condition of the property, like in prior owner being the town and the gravel pit.
right.
Bottle down.
Well, it's basically, back in 2004, my younger brother wanted to build, he needed a house, needed a place to live, so this Kevin Lappin, who apparently he bought a chunk of land from the town of Waldoboro. I think it was like 10 acres maybe. Kevin subsequently broke it into 5 lots, building lots. And my brother bought lot 4, I think it was, and I bought lot number 2. Lot number 2, the one I bought, went down to the river from the right of way. His lot was on the other side of the right of way, bordering on the 32. And so he had the Rockport Homes. They put a modular house on a foundation there for him. And it was Don did the site work and septic. Did you do the septic too?
Yep.
He did the septic. And Stan Waltz was the active code enforcement, did the inspections. And anyway, that was how I got involved, because I'm a plumber. I did the heating system and connected the plumbing from the modular home. And so there was a lot across from them for sale number 2. So I decided to buy it. I didn't necessarily, I wasn't planning on building right away. So
Will you describe the property when you first had a
so
look at it?
when I first got it, it was in the summer. There was, that's why I wanted to pass this photo out if you could. It would,
May I?
Yes, yeah.
Sorry, Russ, that I can't provide you with a copy of it. I don't know. I don't know how we can. I-
So we're looking at a Google Earth picture.
yes.
For both, and yeah.
And I just drew the boundaries in kind of. This is a photo that the current code enforcement Mark Stoltz sent me when he informed me there was a violation. He's got a yellow line there that shows the 250-foot zone he's talking about. That's the problem where the work shouldn't have been done without a permit. So the circle there is where, like, do you see that where it says dump site? So what it was apparently, and this is what I found out after I bought the property, that site was actually just a stand of bamboo, like solid bamboo. You couldn't walk through it. It was just like a really dense patch of bamboo. And when you couldn't walk the property because it was a hollowed out depression, where they harvested gravel. It was a gravel pit. It was a dump site and a gravel pit. In that zone, you can actually see where the gravel pit was. It was like walking into a big bowl, and there were pine trees around the perimeter, made like a canopy, but under the pine trees, there was just a dugout depression. It was gravel. And but anyway, the way I found it was I was visiting my brother one day in the winter, and my lab came back with a bloody foot, seriously cut, and I had to take it to get sutured up. And my daughters were with me, and it was kind of scary because we thought we didn't know he was cut pretty badly. And so
that's how you found the bottle dump.
that's how I found the bottle dump. So I followed the bloody tracks to this stand of bamboo, and inside the bamboo was broken glass and like old cookware and bicycle parts, and it's obviously a dump.
And again, you had ascertained that the town had owned it prior to Mr. Lappin, and Mr. Lappin's who you bought it from.
I bought it from Mr. Lab. I called him to talk about it, but it was actually 2 years before I realized this.
Yeah.
And he didn't want the phone call, I just figured I would just, it was my fault I bought it. I should have, so I didn't have it was a stretch to buy the land to begin with. I didn't have the money to get it cleaned up. So I just did it by hand, with my pickup truck, and it took me like over a year to clean it up.
Okay.
And it's still not clean. I mean, there's still stuff moves up out of the ground.
Yeah.
Anyway,
So I'll ask you a question about after you found the bottle dump, and then at some point you decided you wanted to do something in the land, and then what?
yeah, so,
What did you do then?
yeah, so it was like 2014, had enough money to put a road in and put a site, make a site there. So that's when I called Don, because he did the work for my brother and worked out great. My brother was happy with it, and I knew he had the equipment to do it. So I called Don and he said he could get to it in a few months. So I figured I'd go ahead of him. I'd get the permits I needed. So I went to the town office right here and went into Stan's office, said, Stan, because I knew him from my brother's house and I've seen him on plumbing jobs. And, I told him I bought the lot across from my brother's, years ago. And that's when he said, you mean the old town dump? I said, yeah, I bought it. And so anyway, I thought I would need a permit for the driveway because some towns require a permit for a driveway. And he was like, well, since it doesn't go out to the 32, you don't need a permit. So he said, but he goes, I'd like to know when you start the work. He goes, can you let me know when Don gets there with his excavator and stuff? He goes, I'll come up and let you know exactly what's what. So I didn't fill out any permits when I talked to him that day. So when Don landed his equipment, I called Stan and he came. Well, I called Stan the day before telling him that Don was coming up. So he came. So he came up and met us there and told us stay. He said stay 100 feet from the river when you build the house. And I had called the DEP before, and they said, well, it's technically 75 feet on the buffer zone because it's not the river doesn't flow into a great pond. It flows into the ocean there. So 75 feet, it would be 100 feet if it flowed into a great pond. But so I mentioned that to Stan. He said, well, that's technically right. But if you build a house at 75 feet, you wouldn't have a front lawn, you wouldn't have a deck. So just plan on minimum 100 feet will give you 25 feet of area where you could have a lawn, you could have a deck. And so that was the plan. There was so nothing's been built there. This land, because I said, Stan, I'm not going to be able to build anything here for years. I'd like to improve the land. And he said, that's fine. You can do a lot of things. You can put the road in, you can bring power in. And I said,
Stan come to the site?
Stan came to the site, met Don and I there with the equipment there. And, he wanted to know what was going on. And it was basically a verbal plan to him.
Yeah.
I told him it'd be years before I had the money to build. I said it'd be a retirement place, which now isn't that far away. It's 3-4 years, and
Again, this is all back in 2014.
back in 2014.
Yeah.
So, we did.
Did you talk about permitting when he was on site?
We talked about permit. We talked about the building permit. He said, you won't need anything until you get ready to build. And he said, don't apply for the permit until you're ready to build because you'll only have 2 years to finish the project. And then you'd have to apply for an extension or what it gets, it's not cut and dry.
Things
So
get tight.
yeah, so wait until you're ready, but you can improve the land. You can cut that bamboo down. You can improve the road, put the road in. I mean, you couldn't walk to the river. There was no way to get there. And Don knows that. He did a great job figuring out how to get the road in. There were berms, big piles of, stuff left over from when they excavated the gravel. And he was able to figure that out somehow. He made it look like it does now. And anybody's welcome to drive down in there. I don't put ropes up. I let people launch canoes.
We think like a site visit, to the extent that that's ever something the planning board would be interested in, we welcome that. We'd like for you to see how Mr. Daggett's improved the property. Meaning, it was literally a dump and it was a gravel pit, and now it's just much better. And there's nothing to hide. When you were doing the work, did you take any measures to prevent erosion?
Oh, that was Don's idea, and I think it was a good idea. I don't know if it was a law or a code, but Don said, go get some silt fence and you put silt fence up to keep any debris from washing into the river, just not necessarily erosion, but just from the dust. And if we got rain, it could go into the river.
Yeah, so you
So-
took
so-
those steps.
Yeah.
And then did you ever hear anything else from Stan?
The only other, so I made all the improvements that I could afford, and it was good. It was passable. You could drive into it. my daughters wanted to camp out by the river or near the river, so I built a tent platform out of 6 pieces of plywood. Didn't have to cut anything. They're just 6 pieces laid on 2x6s. And turns out it was 2 feet too wide or too, so I needed a permit because it exceeded the size that you could build without a permit.
Deck
So-
actually was 16 feet by 16 feet after those plywood.
Yeah, or 16 by 12 or something like
May I
that.
approach, this is the letter from Stan back in 2021, where obviously he was back at the property. He's well aware of everything going on.
Yeah, he sent me a photo of it and the town reassessed my value because of it. I think I had just under $300 worth of material. It took me 3 hours to build it and they assessed it at $3,500 back in 2014. So, you know, of course, my taxes went up and it took about 1.5 years for it to come off after I removed it. Well, anyway, Stan sent me this letter and said, you know, I'm in violation of this thing because I built it a little too big. And so he said, you either relocate it, cut it down or remove it. So I just removed it. And yeah, I never did see this one.
Yeah, that was something that I wasn't given that by the town. I asked for a Freedom of Information Act request from the town because the indication from the town had been, well, there's been no correspondence about this property. Clearly, Stan Waltz knew everything about this property and he was down at the property in 2021. He was down there again and sent a letter because this tent platform had been built without a permit. And so Mr. Daggett took it down.
Yeah, I think just to avoid this, I mean, this permit fee would be more than I even paid for the material, I just know I removed it. He sent me a letter back. It was either email or a letter. I can't remember now, but he did thank me, which I thought was good. You know, not too many people thank somebody for doing that, but he did. So
So you had a pretty good rapport with him?
yeah, I didn't have any issues with him. He was pretty straightforward and he's been doing it a long time. You know, I think he would have advised me on this. I don't know if there's gonna be a flurry of other cases like this where he didn't ask for a proper permit. I don't know.
Right. Or,
I mean,
right. Let me ask you this. Did you, other than that letter that I just showed you and your correspondence back to him, did you hear anything else from the town about your property other than your tax bills? Until very recently.
oh, then, yeah, no, I'm so from that was in 2021 when the tent platform incident went on. That got resolved pretty quickly. And then I did contact him to find out why they hadn't reduced my taxes after a year. And he said it takes a while. He goes up quickly, but it comes down a lot slower. So that time of scenario, but it was fine. It was I said, all right, as long as it happened, it did, it came off. That was 2021. Now we're looking at this year, September. So what, 4 years?
It was 11.5 years from when you started doing the work on the property with Stan present
Right.
until you received this notice of violation.
This past September, yeah, of this year.
What did you do when you received that notice?
Well, the first thing I did is I tried to call Stan because I thought he had retired and I knew I would need his, you know, input on this because he's the one I worked with. And when I called his cell phone, I had a cell phone number in my phone. I called the number and it said it wouldn't go through. I think it had been changed or whatever. So I called the town office and they said that he passed away. And apparently this was his replacement whom I'd never met. But
You
I
get a phone call?
I know, so I called him. I called the Smart Stoltz and told him basically everything I've just told you, not in this much detail, but I told him that I worked with Stan. He came to the site, you know, I told him I'd been in his office asking for a driveway permit. I told him that he was at the job site with the site worker and he said, well, I can't speak for the prior code enforcement, but all I can say is that you're in violation and we're going to hold you to it. So.
I think if any board members have any questions for Tom right now, that I think might be a good time. Otherwise, I'd like to ask Dawn, who also was on site working with the town code enforcement officer on site, to testify as well.
The deed conveying the property to you was 2015. You said that you had acquired the property in 2003 or 4.
No, I acquired it in 2004, wasn't it?
Yeah, I'm pretty sure it was 2004, and I have that, I can, 2005, I know 2004, and I can show you the reference if you don't mind. It's in the deed that you're looking at, if you look at the next page of it. It says, like, for further reference, you'll see the deed from, to Daggett. That was Tom Daggett, and then he was married, and then he divorced, so there was some, that's why this one that you're looking at.
Okay, okay,
Is much more recent.
okay.
Thanks. Thanks for bringing that up. I meant to clarify that.
I just have a question on this photo that you distributed. The date of this,
That was provided by the code enforcement
Yeah.
officer.
That's not my photo.
What's up?
That's not my photo. I submitted to the board. There's photos in there. You should have that I've submitted to you.
Oh. Are you the code enforcement?
Yeah.
Oh, you're Mark?
Yeah.
Oh. I didn't know that. Yeah,
yeah, I mean, in our packages, we got from, from the town, two photos, one from 2014, June of 2014, and one from June of 2018 that shows the property. Sort of one 2014 Google Earth. It appears as though it's a densely wooded property, and then in
Those are
2018.
color. I don't know
Oh,
if
yeah.
those will help.
So what was the, excuse me, what year was it densely wooded?
2014.
yeah.
So I'd love for, well, if you have a question about that, I'd love
Well,
Mr. Bowden
Yeah, and
to
he's,
tell you what it was.
I'm
like.
assuming you're gonna answer my questions, but in general, I'd like to hear a little bit more about the improvement to the land that you spoke of. What you actually did to the property
Great.
in question, since that seems to be at the root of the issue.
Why don't we
Well,
start with
the root of it-
driving, and then what the property was like, and what work was done, how many, literally how many trees were taken down? And then,
Yeah, the main canopy, which, I mean, the summertime photos is kind of deceptive because, you know, a small tree looks, when it's leaved out, looks like a big tree, but the biggest trees were, I'd say, 5 or 6 big pines around the perimeter of this gravel pit that was made like a canopy, and then there were smaller trees, but you have that photo of the winter,
I do.
this is another good photo, It shows it what it looks like currently.
may I?
Yeah, you can
So
proceed.
this is just the other day. Which shows, it's not the big clearing, that's a neighboring property. It's the smaller one. You see the driveway coming in. Yep.
Yeah, that's, obviously, that's the one adjacent. You know what you're looking at, right? This is mine here. This is that one. It's pretty clear, but just wanted to show you kind of like what the trees were like. It was like this on this property, except there were pines around this perimeter of this. I mean, this is leveled out now, but that was a.
Maybe better, Tom, to describe to the board, again, because, you know, when I hear densely wooded, it gives me reason for concern, because I've spoken to people who were there in 2014, yourselves and Dawn, and talked about how the majority of that property was already barren, it was a pit, and it wasn't densely wooded, so I just like you to.
I mean, there was really no usable wood on it that I saw. The pine trees were cut and used as fill to fill out lower levels, like the trees were gnarly and there was no value to those. There was no
Right.
reason to not just leave them and use them as fill. I mean, if you walk the land now, you'll still see where it dropped down. You'd have to rappel down it. You can't walk it. So that's where they hollowed out all the gravel. They excavated all the gravel, used it for roads or whatever they did with it back then, you know, and you know, the stuff I pulled out of the ground, you know, there was no plastic, so it wasn't modern, but it was probably, you know, there was some Bakelite stuff in there, so it was probably from the 20s or 30s.
Yeah.
When the, you know, so,
And so the five or six pines around the perimeter, and then there was
There was
some smaller hardwood.
more like what you see in this current photo here. It was shrubbery like that, but in the summer it would look, you know, it would look dense.
Filled out.
You know, and then you had the big bamboo patch in the summertime. If you want to see like a good example of a bamboo patch, you can go down there in the summer. It's there now, but it's not as dense as it would be in the summer, but there's no bamboo anywhere else except for that covering that bottle dump. So, I mean, I don't know magically if it just grows there like that or what.
Perhaps tried to
I mean,
put some vegetation over the dump or something.
I mean, you know, and they say there's no statute of limitations on these violations. So let's go back to when the town owned it then. There's no statute of limitations. They obviously used it as a bottle dump and excavated gravel out at the riverbank.
Yeah.
And so,
Yeah, I don't.
I mean, I'm not,
Were any trees taken from the property for any type of milling or harvesting
no,
purposes?
no. Like I said, it was, the pine trees were, you know, they weren't usable.
Yeah.
Um,
All right,
there's still some existing pines. You can kind of get an idea of the size, you know, they were big pines, but the roots were ripped out and put into lower levels. I mean, I thought I had full permission to make a building site
Yeah.
because,
you did,
you know,
but let's let Dawn, unless there's more questions for Tom right now.
Any questions for Tom? I don't believe so. So yeah, let's move along with the next person.
Don, do you mind getting up at the podium here? Big Tom.
What's the date of this?
Our impression is that that company is now, and because I certainly didn't create it, Tom didn't
I
create
think
it.
that was, do you have the date on that? photo?
That's not my fault.
He's saying that he didn't
Is
create
that
it.
the back photo? That's the one I got in the mail from code enforcement.
So.
This accompanied the violation.
Dates of the photo that I had were on there. Those are the ones from Google Earth. So when I did. It's kind of getting into my testimony. I don't want to get too far into it, but
Something, 2018.
So it's
correct. And then the other one is dated as well, 2014.
Well, this one says 2024. Because I think what you did is you sent a photo of 2024 to what it looks like. This would be what the site looks like now. And then you sent one, you know, the backside shows 2000. Well, that's dated 2014. So there's two different,
So this did come from
this is from,
That might have been on the initial,
well, it did come, just to be clear, it came from the code enforcement officer
Okay.
to Tom
yeah,
Daggett.
this originated from
This is
here.
not anything we created.
No,
And
and this
this-
yellow line is from.
What do you think the
this
date
is-
on this one is, 2014?
I defer to the individual that created it.
I'm sorry, what was the question?
What's the perspective, what's the best guess on the date for this?
I do not know. If that was the one that was sent out, it might have been a current picture of the property, the last time the Google Earth was updated.
I have the date right here on this one. I have the original here. You have
You're right.
dated June 3rd, 2024,
Okay,
the one you have. June 3rd, what did it just see right here? 6/3, 2024, and this came from Mark. You know, on the
So
backside
just to
there.
be clear, it's possible to go back in time on Google Earth and find old pictures in Google Earth?
Yeah, that's what he did.
All right.
That's how.
So that this is to clarify.
Yeah, so this is.
Yep.
6/23/14.
yeah, I can see that.
So it shows you the difference. I mean, I see why he sent it because it shows the difference.
This one is 2000. This one's 2018.
Well, the original that he sent me says 14.
May I
See it
see
right
that
there.
picture as well when you get a chance? I just want to see this picture.
Anyway, so. So you have a, you've got an area cleared for the driveway, but,
This is a different site here, but yeah,
Yeah.
this is the driveway here.
right.
But the reason for this photo is just to show you what
Well,
the type of
this
tree.
is, this is snow covered, so.
Right, that's
Yeah,
the road.
Okay, yeah.
Is this like a drone picture?
Yeah.
Yeah, so somebody flew a drone.
Yeah, it's a
Alright.
drone photo.
You want
But this
to
is
give
this is the
perspective.
lot next to me. This is my
Yeah.
lot here, but I was just did this so you could see what the type of trees were.
Is there stumpage in here that would be like where the trees were? Because I don't really see. any
No, the
stumps.
stumps were pulled out
Yeah.
and put into a lower lying area to help build up the gravel pit.
All right, that would make sense.
Because it was they were, when it rained, it'd be swampy or whatever, and it
Yeah,
would take a while to drain down through the soil, so
well, pine rots really fast, so it would be gone by now.
probably.
Yeah.
So anyway, this is the original, this was the initial violation notice that I got. So it was 2014 it showed, and then 2024. Two different summertime. I don't know if they're from the same elevation.
Still,
Yes,
still,
Still confused.
And I just want to emphasize, like, again, that's not anything that we created. It came from the code enforcement officer with the notice of violation.
right,
And I don't know anything about how, how he pulled it up and so
Yeah.
he'll be able to.
yeah, I mean, you can go online and you can search, Google Maps and
Right.
from all over the world, and
Yeah.
yeah, it just shows that that was the aerial view in this particular photo from June of 24. We also have Google Earth photos from June of 2014 and 2018.
See, I never got the 2018
Yeah.
one. That
So, I mean, this is. In 2014, this is what the. Satellite imagery of the property looked like on
Right.
Google Earth.
that was that would be
2014.
just before the work was done. Because the work was done in 14.
Tom, I think we can let Don testify a little bit, because I
Do you
think I
wanna
just want to
see
get
that?
to
Yeah,
the,
check it
to the
out.
rub here, which is
You would like to see that picture there.
what things are actually removed from the property.
Yeah.
Which.
These are the comparisons. between-
Oh,
So I'd like to let Don answer a couple questions.
Yeah, we're just taking a second.
Oh, yeah,
He-
no
he-
rush.
He wants to look
Yeah.
at because the pictures are now like, we're looking at them, so we'll take a moment to,
Of course.
and then we'll,
Digest.
yeah.
this one, so.
Okay.
You know, this was cleared out between,
14 and 18.
yeah, okay,
Which is
yeah.
all we're looking, this is just what we have to look at, so we're not gonna do a historical Google look back, so we'll just go, we're working what we got.
Yeah, and it's fine if
So,
you did. We
yeah.
know it was done in 2014 and Don was there in 2014 and he knows what the site was like in 2014. Just like Tom does. Tom has told you. And we have
Yeah.
evidence that Stan Waltz obviously knew about the site because he sent a letter in 2021. In addition to the testimony, the evidence that we've heard from Tom.
So, let me understand. There's clearly, not a lot of cleared area in the 2014. Which appears in the 2018 and the 2000, and the current one.
Yeah.
And you said that was, where, there was a lot of debris.
Most of the debris, the dump part of things was along the driveway just before you get to this, to the.
Yeah, it's on the other photo, the first one we passed out.
Yeah,
Yeah, Right.
So where would that, this
That was,
area?
that,
This is dump.
right,
See this?
Where you-
site, and then,
circled.
and most of the pit was here, most of the dump was there. And then the driveway where most of the, bamboo is, as I understand it, is along the
Bamboo.
drive.
See where the drive, see where it says dump site?
Yeah,
That's where the bamboo, was.
Okay.
It was
Okay.
covering the bottle dump.
Okay, so that's why it's green.
Uh,
That's why it's green in the 2014
oh,
photo.
probably.
The 14 one has a lot of green vegetation, but
Yeah,
it's,
that's-
it's really hard to figure out what kind of trees or what's going on the ground.
The trees, yeah, the bamboo would be where that dump site is here, so you'd have to kind of transpose it. I don't really
No,
know.
a lot of it's still there. Again.
Yeah, it's still,
Encourage you to visit if necessary.
Um,
So it would look green and it's bamboo. It would look green and vegetated.
I mean, I've tried to get rid of it, but I didn't want to use any chemicals near the river, so I tried to pull stuff out and cut it down, but it's, it's not going anywhere.
So just to reiterate, this property was originally owned by the town? Is that historically?
I don't know that.
All right, but and you purchased it though from somebody called Lappin.
Yes.
Right.
But this idea of it having been an old town dump,
Hmm.
is that just where people sort of, got used to throwing their trash, or it was physically owned, it was actually owned by the town and it was a town
I
dump?
think it was bought from the town,
By Lappin.
Lappin purchased it from the town of Waldeboro.
Daryl
Yeah.
might be able to, I can go grab the records. I don't
That'd be
go
great.
back that far.
Yeah.
Thanks.
And I guess the issue is when you bought the property,
Hold on, time.
was or wasn't there a road already established on the property to and from this gravel pit area?
There was a road into it, yes. And here's the thing, there was a house built, I believe, in 96. Genthner built a house in 96, and I think he bought it from Lappin too, so the sale from the town would have probably been in the 90s, I'm guessing. So. if you-
So
if you-
Riverbend
that
Road
house
is not a
too.
town road?
No, it's a subdivision,
It's a
Yeah.
private road.
It's a private road?
Private
Okay.
road.
and I did that house too.
Oh, you did Gentz's too?
Yeah.
Oh, so you did every,
Through through Kevin Lappin.
okay, so.
He built it as a
Do you
spec
know when
house.
Kevin might have bought that from the town, that property?
I don't know exactly when he bought it, no,
What was that, 96 when you did Genthner?
right around there,
Yeah,
I don't
so-
remember.
So there were 5 lots and all of them were roughly 2.5 acres, so he probably bought 10 or 12 acres, lap and Kevin. And then split them up, he divided them up, and my brother bought one, I bought one, and there's two other ones, and somebody's getting ready to build. Soon, it looks like, I don't know the particulars, maybe Mark knows about that.
I think in the interest of moving along,
Yep.
we'll start with him giving his testimony. We'll search in the records and all that
Thank you.
stuff. All right.
That's great. Yeah, so you state your name for the record,
Don Bowden,
and what's your vocation? What do you do for?
I do excavation, self-employed, been doing it for 30 years.
And you've done some of the projects down in the area that we're discussing,
Yes,
including Tom Daggett's property.
yes,
And did you know Stan Waltz, the former code enforcement officer?
yeah, I did,
And how did you know him?
through the code officer, as, doing septics and getting permits for different houses and stuff.
Okay. Were you on site at Tom Daggett's house at any time when Stan Waltz was on site?
Yeah, I was there one time when Stan came down.
And so Stan was on site while you were doing some of the work?
Yes,
Yeah, and why don't you describe, please, what the work consisted of? Because we've heard from a couple, about densely forested, was this a densely forested property or?
no, it wasn't really dense. I call them, pasture pines. Because the pine trees in there were just, they were junk. And I knocked them over and pushed them to the back of the pit to get rid of them. And there was
And when was what was the date of that construction type? work?
2014.
Okay.
That was the same time that Stan was on site with you?
Yep, yes,
And so the pines were knocked over and to help fill in the pit and level things out.
Yeah, because the pit had overburden up on the bankings. And I took the dirt from there and brought it back into the pit and graded it off and flattened it out.
And how many, like, how many trees do you think in all were cut?
I just knocked them over with my excavator. I didn't cut anything. I just knocked them over and because they
them out.
weren't really that big.
Yeah.
And this was,
But I mean, there was a lot of bamboo in there and a lot of thorn bushes.
Oh, yeah.
Thorn bushes were unreal down there.
So about it.
What was the, just, what was the diameter of the trunk and of the typical? pine?
They probably were, like the trunk is probably like that,
On the pine trees.
on the pine trees
The other trees
were small,
yeah.
like all the bushes and stuff like that.
I mean, is there anything else remarkable? Did you see the dump site that Tom referred to?
Yeah, because I pushed that back into the bottom of the pit.
So you helped try to clean that?
Tried to clean that
panel
glass up. There's a lot of glass everywhere.
Yeah. I mean, that's how my dog got his foot cut, just walking through that, so. I mean, probably a lot of animals over the years have been hurt on that, I mean, not that, I mean, what are you gonna do, but,
So
now it's much better than it was.
So other than the 5 or 6 pine trees around the perimeter of the pit and some small hardwoods and thorn bushes and some bamboo, what else, if anything, did you do on the site?
What did I do?
Yeah, like what else? Can you describe it for us?
There's, because it had a, big drop off with a lot of overburden up on top. And that was, a lot of it was down closer to the water from the 75-foot setback up this way. And I took all that and brought it in, and then the banking towards the main road had the same issue, but that was like 20 feet drop off, and I pushed all that in, and then I graded that all off to a slope as much as I could, and it didn't fill the whole pit up because it still has quite a depression along the outside of it.
Which is another thing that will help for the board to actually see, like, that it was a pit and it's been somewhat reclaimed. But there's still a depression there, and it's not, there's no evidence that there was never, well, in recent history, there's never been any dense forest in that location. There's been a very small operation that was done with the approval of Stan Waltz, with his involvement. And if there's anything else you can describe about the property, that's great. And if you have any questions of Dawn, I encourage you to ask him. Otherwise, I'm gonna actually get up and talk about the law a little bit.
Yeah, I just want to clarify, since I'm the one that first used the term dense forest, that I just want everybody to recognize that I only refer to my description of the Google Maps satellite imagery from 2014 that makes it appear as though this is a densely, a dense woodlot.
I'm certain.
And, I mean, you also did say originally when you bought the property, the vegetation was so thick that you couldn't even have like the access to the water,
No, you could not through the bamboo.
not through the
You
bamboo.
could
Okay.
go on other
Okay.
people's property, like there were hiking trails on other property, but this land was inaccessible. There was a narrow band, but there was bamboo there, and it was obviously the property had been used up and abandoned, but Kevin Lappin purchased the whole area. He didn't just buy like me. I bought the worst lot there, right? So, but he bought the whole 12 acres or whatever it was back. We'll find out when it was bought from the town, but this place was left in pretty hard shape.
All right.
And is what Tom's saying, how you found the property as well?
Yeah, it was a mess.
It's not like you came onto a property that was heavily wooded and it'd been any forest operations going on there, cutting wood.
No, there was no operation. It was just I would call it a reclaim.
thank you very much, unless there's any questions.
Any questions? Mhm. Okay,
Thank you, Don. Appreciate it. Mike, if you want to tell them about the history of the property, maybe?
You've never heard of this 250 foot, I don't know if that matters or not, but I mean,
We'll come back to that.
yeah.
Yeah.
in grabbing the files, kind of interesting. I researched all the deeds. I'm Daryl McKenney, been here since I was 19 years old, been here 43 years, do with the assessing, did the code prior to Stan coming aboard. This lot was actually owned by William Thing. William Thing used to be the operator of, or the CEO, I believe, of Sylvania. And lived in town until he passed away. But anyways, obviously there was an old dump there, but I don't know that the town ever owned it. It certainly used it. Bill Thing got it in book 578-251, and it doesn't have a date, but he got another piece in 1965. So you go back in the 60s, it was in William Thing's property. He then sold it to Kevin and at the time Diane for $22,000 in 1988. They took the property and did a subdivision, did a 5-lot subdivision.
How many
And-
acres was it? Excuse me, how many acres total?
Well, there was the big question was, it was over a lot to take it to the state for state approval with 5 lots. So they ended up giving land away to the north. So it was right around I have lot 4 is 4.5, 8, 10. Must have been the 25 acre deal.
Bought
You
that
had to go to the state.
for 22,000.
For 22,000, they paid for 25 acres.
Yeah.
There was probably 30 acres there, but they gave 5 acres away, so they didn't have to deal with the state. Lots of things that have gone over the.
Yeah.
The other interesting thing in just pulling this file is there were 3 conditions put on by the planning board. And number 3 says lots 1, 2, and 3 shall have a deed restriction of no building within 160 feet of the river. And looking down through the notes, it was concern, but again, we didn't get into that. And I don't think it must not be in your deed, probably never followed through.
No.
I don't think it's on the plan as a condition. So in the 80s, things
Right.
come out. I don't know if that answers those
That's helpful.
questions.
No,
Yeah.
thank you.
So that's why it wasn't a state, I mean, it wasn't a town road, it was just a private road that's local people use for dump their garbage or whatever.
Right, was back before my.
Yeah.
Now I'm gonna provide each of the members of the board with the 5 different notices of violation that we've received since first one's 9/11. And then there's subsequent, we're just trying to figure out which of them, frankly, what's being violated and what the rules are. The first notice of violation, you'll see dated 9/11. It cites to the current land use ordinance, section 11.7.2, and just says permits required. After the effective date of this ordinance, no person shall, without first obtaining a permit, engage in any activity or use of land or structure requiring a permit in the district in which such activity or use would occur or expand, change, or replace an existing use or structure, or renew a discontinued non-conforming use. Then it just says, it appears that vegetation removal has been completed within the 250-foot shoreland zone without any permits, but it doesn't provide any specificity with regard to when this took place, what ordinance was in effect at the time that it took place, and it doesn't cite the ordinance provision that's being violated. So, but it's a notice of violation. So anytime I have a client that gets a notice of violation, if we don't appeal it, then though you're essentially giving up your right to dispute the violation. So we did appeal it on October 4th, and that's part of the application package.
And as you'll see in this, the package of violations, the next one came on 11/4. Well, actually, before I get to that, and and the reason I don't like to harp on things that aren't directly pertinent, but this has been a very frustrating experience, not only for Mr. Daggett, but for myself. I've been practicing municipal law for 25 years. I've represented the towns of Cushing and Warren, and I've represented hundreds of clients in front of different municipalities. And I just wanted to clarify with the code enforcement officer, this is Exhibit B, about the fact that we were just appealing the issue to this board. And I was told I couldn't, or I guess it says, an appeal to the Board of Appeals is not permitted under this current ordinance. So we had to have some discussion about that, but it was never clarified to me that the code enforcement officer agreed with my assessment. We just got subsequent notices that of violation instead. Which you see the second one is dated, I think I just said it's dated 11/4. And it's very similar, but it's also different. It doesn't say anything about a 250-foot setback. It just says you have 14 days from the date of this notice of violation to apply for an after-the-fact shoreland zone permit. It must include a revegetation plan that complies with Article 11 of the Shoreland Zoning of Waldeboro Land Use Ordinance. So one cannot be penalized for, in a current ordinance, for violations that took place when the ordinance didn't exist. Now, there was an ordinance in place in 2014, but it wasn't this one. But there was, as Mr. Stoltz sent me an email 2 days ago, explaining to me that, well, back in 2014, there was an ordinance in place that had many of the same provisions. And so he made reference to those. I don't know which ones he's asserting that have been violated, but as we go through these additional notices of violation, I'll explain further. I may try to make sense of that. The next one is dated 11/5. And it's just, it's the attachment, excuse me. So it's the attachment to the 11/4, but it's dated a day later. And I think the intent was to show what the fine would be, you know, because his position is that there's been a violation. And so then the next one was 11/13. And 11/13, this notice of violation, well, it says, it doesn't say notice of violation. In fairness, it just is a letter saying, while conducting an investigation, it was noted there were 2 storage buildings on the property. One structure was a wood frame building with ventilation screening. I took a picture of the inside to the screen, and then the structure is consistent with a primitive bathroom known as a pit privy. So Mr. Daggett went back to his property and there's no buildings on his property. So this was, the CEO was saying that this was on his property. It wasn't. And so, but the taxpayer, the landowner, was required to go to his property. It's 200 feet off his property, but he sent a picture, I think, in correspondence to the code enforcement officer to explain that it's not even his property, but he's got a letter from him saying that it was. Subsequently, the next one came in on November 14th. This notice of violation, as you can see, is much more extensive. And this is 6 weeks after we had submitted our initial notice of appeal. And we did respond to this one as well, in more detail. But this one, as you can see, makes reference on the second page to the right of appeal and to appeal that we can appeal it to the Waldeboro Board of Appeals, which was encouraging, you know, because you need to exhaust your administrative remedies before you before you take anything to the Superior Court. You know, you just take care of things at the town level ideally before having to go to the Superior Court. So, after receiving the fifth item of correspondence indicating a violation, I asked, for some clarification. Actually, it wasn't directly after receiving it. It was more recently that I asked for clarification as to what year the ordinance was in place that he's referencing, because the work that was done by Don and Tom was 2014, and you can't hold someone responsible for 2014 actions in a 2026 ordinance. So he made reference and he said, well, if you compare, there are some provisions that were identical. So, and even those provisions that are very similar from 2014 to now don't establish a violation of the ordinance. Now, more to the point, I guess, really to the point, 12 years ago, if this town gets in the practice of trying to establish violations from 12 years ago, it's not a precedent that is sustainable. You can't, I mean, Mr. Stoltz responded to my problem with the 12-year issue and the fact that, a code enforcement officer had been involved with it by saying, well, there's no statute of limitations on the shoreland zoning ordinance.
Yeah.
That's true.
Can I ask you a question?
Yeah,
Is there a legal thing called unreasonable delay of enforcement?
yes, it's it's called laches, which is, it's Latin for basically what you just said. And there's also another, it's called equitable estoppel. And equitable estoppel, which is why I brought my Board of Appeals manual, because they have some pretty good, language about these types of issues. In deciding whether a municipality should be estopped, it's a funny verb, right? But the court will consider the totality of the circumstances, including the nature of the particular governmental function that was being discharged, and any considerations of public policy arising from the application of estoppel to the government function. And that's actually a Town of Union case versus Strong. It's just not fair from a common sense standpoint for something that took place 12 years ago in an old dump site, when you're talking about if a dozen trees were removed, 5 or 6 pines, with Stan Waltz's approval and awareness. There's no way that Stan Waltz could have provided the notice of violation in 2021 for the tent platform unless he had been down there. How can 12 years elapse and a taxpayer and a landowner be held to this type of scrutiny? It won't pass the straight face test. And I'll be honest, I think it puts the town in jeopardy of having attorney's fees. Because if the board was to, say that no violation it's all good, there's a violation and we want to enforce it, we'll appeal that to the Superior Court. And there's a provision in the ordinance actually that Mr. Stoltz cited that says if there's unreasonable enforcement, selective enforcement, that the party against whom that selective enforcement is being attempted can receive attorney's fees. In the case Tracy Hoffman versus Town of Washington, I represented Mrs. Hoffman and she was granted her attorney's fees because Robert Temple was the code enforcement officer at the time, and there was selective enforcement, and the Knox County Superior Court agreed with us, and there were $10,000 in attorney's fees granted. This is not reasonable. I don't think it's, that Mr. Stoltz, he doesn't know Mr. Daggett, so there's no ill will, there's no malice or anything. He thought that there was something wrong, but I've never seen a code enforcement officer try to enforce something from 12 years past, and especially in this context, when the town knew exactly what Tom Daggett was doing at the time it happened. I have other, citations, but I don't think it's necessary. I'd like to kind of reserve 5 minutes if I need it after Mr. Stoltz gives his testimony. Thank you.
And are you ready to present? Sure.
All right. So there were some things I'd like to clear up first before we proceed too far. One, I totally agree with what he's talking about as far as selective enforcement. I don't do selective enforcement. I don't treat anybody any different, and anybody that's worked with me knows that. I treat everyone the same across the board, don't care who it is. So there is no, and like he said, there's no statutory limitations on shoreline zoning. So that's one of the things that we did. How we came about this whole case was I received a sales questionnaire, and Daryl approached me about 30 Riverbend, and it said that there was a bunch of tree removal and costs and stuff like that. And there was questions on Daryl's mind whether or not there was some type of violation of the shoreline zoning and stuff like that. So that's how I got that information. It came in as there was a possible violation. In doing my job, some of the stuff that I do is I do a lot through looking at overhead views. Google Earth is a great resource to try and figure out, well, what was done, to what extent, and stuff like that. That's how I was able to find out. I did also note that there was a violation at, and we have it as number 31 Riverbend. But there was a violation at that property as well. I've been working with that individual in order to clean up those violations and do some revegetation as well. So again, I don't treat anyone any different. That person was given a violation for the same thing. The only email that we have, the only correspondence period we have from Mr. Daggett and the town is the letter that went out from Stan Waltz on that 2021 date. That letter basically is a generic letter that Stan Waltz had typed up that he sent out to people that basically came from the assessor. The assessor basically, when he goes out and does his assessments of property and stuff like that, if he finds that there's been some type of building and it's not showing up, it's new, there's no permits on the file, he lets a code enforcement officer know. The code enforcement officer then sends a letter to the individual stating it was brought to our attention. And then, this is what we found and this is what is owed in order to do that. So that's where that information came from. And then on the back of that form, there was a notation in there. I believe that was your thing right in there. Yeah. So there was a notation on the back of the card that basically, this is what it was, and this is the form that basically gets forwarded to the CEO. I trained under Stan Waltz for a year before I took over. So I know Stan Waltz very well. I considered him a friend. So I know what his habits are. I know what he did in that point in time. These letters that he sent out, on the ones that I'm aware of, he never went out to visit the site before sending out the notice of violations. So to say that, Stan Waltz, because of this letter, had to have been on site, I don't find true at all. So.
So then, Can I just ask a follow-up
Sure.
question? So then similarly, when Mr. Daggett corresponds back that he's removed the tent site,
Mhm.
there's no verification of that occurs?
Not to my knowledge, and as a matter of fact,
Before the taxes get reduced on the property?
I go back and verify that it's been removed and take it off the tax rolls. Yes.
Okay, so basically what I'm understanding is that you noticed the tent site, you reported it to Stan, and then Stan follows up, and then you go back and you confirm that it's been removed and
Take it
the
off.
taxes, the tax assessment gets adjusted.
so the only photo that we have was from Mr. Daggett with a photo of a dog where some site and stuff had been removed. I'm assuming that's where the platform was. I don't know if you guys were given a copy of that, so.
Didn't receive a copy of it in our, full response either. First time seeing, thanks.
Oh, can I see that?
That was his email, so.
Why is this? This is the first time I've seen this.
I think that's a picture to verify that it's not there anymore.
Yeah, I mean, that's my dog. That's the one that cut his foot.
Right, but that picture is not from Stan Walls. That picture is from you in your email.
Oh, to prove that it was not there.
Yeah,
It was something that you sent, that's all I was saying.
Yeah, so June 14th, 2021, Tom sends this email to Stan. And again, I submitted a forward.
Oh, could I see the, I wanted to know.
Well, hold on a second,
Oh, sorry.
sorry. I submitted a forward request asking for all information relating to the case and the property. And just want to put it out there, like, that was not included in the information that I was provided in any event.
Why wasn't that, I wonder?
I don't know.
all right, let's continue with yours.
Let him go.
Okay.
Right now, whatever it is, remember.
I mean, the Yahoo address lobster 40467, that's you,
I
okay.
was curious, what Stan, can you respond to, could you give me his email?
It's on that document.
On the
Yeah.
document? And
Lobster 4040.
No, Stan's.
Stan sent to,
To CEO at waldeboromarine.org,
Maine.
Okay, well, sorry.
waldeboromaine.org.
Thank you.
it's just, is there a CEO in front of it?
Just, yeah,
CEO at
CEO at-
Waldeboro Maine.
CEO at,
Waldeboro, Maine.
It's Same as the current CEO.
MAINE or
It's the
ME?
same, it's the same as.
Yeah,
There's no change, we don't change
Oh.
emails
And
when.
this is
we-
dated June 14th, 2021 on a Monday. Is the email.
Thank you.
Yeah,
So when the platform's gone.
yeah,
Yeah. Right.
okay, we'll continue with them.
So the notice of violations, I know that it was brought up about the multiple violations. I sent a notice of violation and then a follow-up violation. As far as the response, because I'd had one conversation with Mr. Daggett, but I had no other information, whether or not he was going to do anything as far as corresponding with the violation. It was at that point where I received notification that he had retained legal counsel, and I had started dealing with that. The counsel had indicated that there were some questions about what it was that was being cited and stuff like that. So my notice of violation, which it does say notice of violation on it, November 13th, 2025, was to help clarify any misunderstandings that there would be as far as the violations and stuff like that. Most people, when I indicate that there's a violation, no permits and stuff, that's usually sufficient and they understand what it is. In this case, I felt like there was some misunderstandings as far as what it was. So I basically had delineated out in the first paragraph what the violations were. The removal of vegetation. It's not just removal of trees. Shoreline zoning is very specific. It's vegetation. It is not just trees that get removed. So So basically, the violations that were listed, as far as part of the responsibility, I have to list out the violations. And then part of what I'm trying to do is get better at citing, if a person has an appeal, that that is listed in there of how to, go about doing an appeal. And then also it is a legal thing that we need to make sure that if there is such a thing as a violation and fees, fines, whatever, we have to spell that out. So I send that out with my notice of violations. And then, it basically covers that so that they know that there could be, either legal action or fines. And then what those fines would be, those get spelled out. So that's why that basically
So just
was
to be,
included.
to clarify that, these are all under case number, was it 167? There's a case number assigned to
Correct.
the
There were
violation?
two different cases that were taken care of. I opened up a second case on that, which is 191, which was used to send the November 13th violation letter to them.
So are you pursuing two separate case numbers?
Yes, because the first one, to council's credit, when I read that one, basically, yes, it talked about the violation, not having, the permitting factors and stuff like that. But in that case, I don't feel that I probably did as good a job as I could have on defining what exactly those violations were. He had asked for that in an email conversation. So I supplied him with that other violation letter, which basically spelled out all the different areas that were violated in the shoreline zoning. So that notice of violation for that November date was to better relay what had been violated and the actual areas of the shoreline zone that had been violated. There was also some questions that he raised about whether or not it was, there was a forestry section in there. You should have read that. That forestry section is in the land use ordinance because towns basically have the ability to say, we are not going to handle the forest operations. So if you had forest land and you were doing a certain amount of tree cutting, actually, can you speak to what that actually is as far as the forestry and the cutting and?
But they didn't do any forestry, as I understand it, but. So basically, the shoreland zoning came about in 1973 was the first time. And so for 53 years, it's pretty much the same language. You need to have a well retained buffer along your property. Now what he's talking about was actually in 2013, the state came out with mandated standards for timber harvest, and the forestry took over. Basically, we could say, okay, you're going to take over intent to harvest and you follow the guidelines. But again, the same buffers are in there. The same openings, no more than 250 square feet, have followed right along, even though it's state issuing forestry versus town.
So Stan, just so I understand the violations.
Mhm.
So are you saying that Mr. Daggett should have obtained a permit for the work he did on the property in preparation of some future, albeit distant future, intent to build a homestead on the
So
property?
one of,
So is it, let me
Sure,
just get,
yeah.
and the second part of my, is it the fact that he did it without a permit? And then in addition to that, permit or no permit, that the removal of the vegetation within the shoreline property didn't meet the land ordinance that you further clarified in the additional case number 191?
That's correct. There would, if there was going to be, if we were going to say that it's okay to clear this because I'm going to build right here, well, there needs to be a building permit on file in order to do that. You can't just clear a lot without having a permit to stipulate that this is the lot where I'm clearing. I could clear a whole entire area, but if I'm only building a 30 by 30 house, well, I don't need to clear a whole entire 2-acre lot in order to clear that space for that. That's part of why you need a building permit in order to go in and clear.
So back in roughly 2014, there
Mhm.
was a requirement that if you had a future intent to build a homestead, you would have to secure a permit.
It would have been okay to clear where you were going to build a house. If there was a house that was being built, then there should have been a permit and we would have known the size of the house, where a septic went, but we don't have any of that information.
Right, but since Mr. Daggett wasn't intending to build a house immediately,
Mhm.
he was clearing the property to, shore up the road and to prepare sort of for the eventuality that he would prepare.
But by their own admission, they stated they knew about the 100-foot setback, and yet they cleared almost right to the water's edge.
So on that
No,
point, can I ask
no,
another
no.
question?
No.
Can I ask another question though? Because I'm hearing about setbacks and whether it be 100 feet or 75 feet.
Correct.
And also then in this latest notice of violation, where it says it appears that vegetation removal was completed within the 250-foot shoreline zone without any permits.
Correct.
And the documentation shows this 250-foot long sort of line superimposed on the Google images. Could you just point out for me where in the ordinance it says that you can't build within a 250-foot shoreline zone?
Yes, so
Because I'm reading stuff in here and maybe I need to become more educated.
so the shoreland zone, there are moving targets to the shoreland zone. Shoreland zone is, in this case, is 250 feet from the high water level of the river. So that's the shoreland zone. So if you measure anywhere, any point from where that river's edge is, the high water mark, 250 feet, that's the shoreland zone. When it comes to what you can do within that shoreland zone, that's where the shoreland zone ordinance basically spells out how many trees you can remove, to what extent you can remove,
Okay.
and how far away from something you can remove.
Right. Okay.
So,
Right. So I guess your position, the position of the town is that there's evidence that within this 250-foot shoreline zone, that some of the vegetation clearing that was done 10 years ago exceeded the land ordinance requirements, like, for instance, no cleared opening greater than 250 square feet. And some of the setback requirements of 100 or 75 feet, depending on what the definition of the waterway involved.
so again, hold on a second until I can get there. So section 11.6.17 basically talks about clearing or removing of vegetation. Again, not trees, vegetation. And it goes on to basically talk about that. 11.6.17.2 talks about other areas. And it basically, with a strip of land extending 100 feet horizontal distance inland from the normal high water line of the Great Pond or river flowing to a great pond, which the Madomic is.
No, it isn't.
According to the town and what we have in our maps, it is. That's what we fall under. We have a map that it's been approved by the town, and that's what we go by. So that 100-foot setback or within a strip extending 75 feet horizontal distance from any other water body, tributary stream, or upland edge. And then the 11.6.17.2.2, that basically talks about the 250 square feet of forest canopy or other extended woody vegetation in the forest canopy.
Which essentially what, about a
Basically woody
15 by 16 lot? Clear cut?
250 foot. It basically
Square-
talks about
square-
250 foot square.
We're talking what, 15 by 16 foot?
Yeah.
Correct.
Clearing,
Correct.
if it's clear cut,
For septic. and-
as opposed to selective cutting.
Correct.
That's under timber harvesting and it's a bird's eye view of canopy. It's a different, you can do up to 10,000 square feet if it's a building site
There you go.
with a driveway, a well and a septic. But didn't have either one really.
Right, so that's what I'm trying to clarify,
There was no
like,
timber harvesting. So, I'm sorry, go ahead. I can explain.
well, no, I realize that there's no timber harvesting
So that's not-
because the work done on the property was to clean up the site and to prepare for some future building of a homestead.
Right. And I was told not to apply for any building permit until I'm ready to build. He said I could make the improvements. He said, when you build, plan on building no closer than 100 feet, so you can have a 25-foot buffer for a lawn before you get to the 75 feet. That you cannot, the state requirement was 75 feet because the Madomic, when I talked to the state, they said Madomic River is not, doesn't flow out into a great pond. So you don't have to have the 100-foot buffer of tree zone, you only need 75. He's saying now that it is, the state of Maine says it's not, so.
And Stan Wall said it.
Stan
All
Wall said the same
75.
thing I said. He said, just don't put your house at the 75 because you won't be able to have a deck, because you can't have a deck extend into that 75-foot, buffer zone. So 75 feet, so set it back. If you, I don't even really necessarily have to have it that close. I wanted to know what the laws were. And that's what the state, the DEP told me that 75 feet, because that's not flowing into a great pond. A great pond is a bigger body of inland water, not the ocean. The ocean doesn't count.
And can I just real quickly, did you measure back, physically measure back from the waters?
We put the silt fence up at like 80 feet from measurement. It's a little difficult to measure because the banking drops off.
Topography.
Yeah, I mean,
It
so
was all thorn bushes.
there's thorn bushes.
Don, did you help them measure back?
Yes.
Yeah.
Did you clear to the, almost to the water's edge, which is what we're here?
No, look at the map.
Okay.
Look at
And
look at
come
2024.
visit it.
All right, well, we'll give you a chance to come back up
Yeah.
when you finish, but I
Yeah,
want
Tom,
to.
let's-
2024, I
Yeah.
don't know which picture it is.
So I guess I'm just gonna read.
This is 2024.
Can I just restate again? So back in 2014, was it the expectation that a homeowner in preparation of some distant building of a homestead, like 10 years out, wanted to clean up the property? Would there have been an expectation for the work that Mr. Daggett did on his property that he would have needed a permit at that time? That's just question number one. He wasn't building a house immediately, but he was planning to at some point in time. And so he was doing some work on his property to prepare for that. That obviously entailed removing of vegetation and trees. Would it have been in 2014, the expectation that for the extent of his work that he would have needed to have filed a permit?
So you're talking about like a building permit? What we do now is, as far as the building permit, I don't do anything shoreline zone wise until I get some type of permit, so I know what we're clearing to. How
we're
can you
building.
possibly
Right.
do something like
Right.
that?
And so if someone approaches you and says,
Correct.
I bought a property, maybe I want to build in 10 years from now, but I want to start cleaning it up. So I'm going to start removing vegetation and trees and whatever.
Absolutely. As long as they follow the shoreline zone,
Right. So.
they can do that. They can,
so no
and then they could clear later on if they develop the site.
Right.
So there are,
So no permit was required back in 2014 for the work that he was planning to do, but then there was a requirement that the removal of the vegetation and the trees and whatever he did needed, however, to have conformed to the land ordinance requirements for shoreline zoning that were in existence in 2014. So, right,
Yes,
so 10 years now later, or approximately
Well,
12,
Yeah.
you're looking at an adjacent property and you see that there was obviously the removal of some vegetation and trees on the said property. And I guess you can go back in time and roughly say it had to have happened somewhere between 2014 and 2018. And I guess the condition of the property today appears as though the red vegetation and removal and the tree removal or whatever exceeded what the ordinance stipulates.
yes,
So the violation we're talking about is for the removal of vegetation and trees on this property 12 years ago that exceeded at that time the land ordinance because there's no statute of limitation.
yes.
Okay,
Well,
I,
what is the purpose of having the violation on the card at this time for activities from 2014? What's the intent of the town in finding something on, like, is there to update the card so that it's accurate to the property, that there's a vegetation issue, or is there plans to try and remedy a problem that was from 14 with modern standards or something? Like what's the intent of the?
The intent was to protect the waterways. That's where shoreline zone came about in the very first place. And then it basically talks about having a well-distributed, vegetative growth to prevent erosion control issues and stuff like that, not just in the short term, but also long term. In 2013, the state came out with the regulations that anybody that works within the shoreland zone and stuff like this must be licensed through the state. So the contractor that worked even in 2013, and I've got that document if you'd like to see it, but in 2013, they were required to be licensed through the state and understand what shoreland zoning is. Regardless of if ours says 100 feet and the state recognizes 70 feet, ours, because we have a shoreland zone ordinance, ours prevails over what the state is. The state basically says shoreland zoning must be done by every community. If you don't come up with something, the state will enforce it for you and tell you that you have to enforce it to this standard, which is kind of like a state minimum. The town of Waldoboro chose back in 72, 73, whatever it was. They came up with the ordinance back then based off from what the state had for that information. That information has not changed over the years much other than some minor wording here and there. So the contractor, whoever worked on that, should have known what the shoreland zoning ordinances were, at the very least that they're required and need to be followed. So with that, the things have not changed. The sections may have changed in the ordinance, but the regulations are still there.
All right.
so then the violation as that we're talking about is that, again, within the 250 feet of shoreline zone, that what was not followed? The setback wasn't 100 feet from the water? Is the
Correct.
town's,
So basically, the violations were, as they translate into, and I translated them from the old version to the new version as well. Here's mine.
and since there was no, there still hasn't been a permit to date to build a house.
That's
So
correct.
since we
There's
don't
been
know-
no permits whatsoever.
I
So
don't think he
since-
plans on building a house anytime soon, do you?
No, no, that's why
So-
Stan told me not to apply for one until. I'm
So-
ready to
But
do
what
it.
was remedied already, though, was the removal of this tent platform without a permit. So
Excuse me?
Yes.
Yeah.
that was remedied
think that was
in the
remedied.
past.
That was remedied, yeah. Yeah. I don't know, I don't know as far as building goes. I basically was told I could improve it and, that's what I did. I improved the property and, I had permission to do what I did, at least from what I gathered. I mean, I had the man there, you heard our testimony. I mean, we had code enforcement on the property. I was in his office, asking about permits for a driveway. There was no.
Well,
John
we've
said this-
established that you didn't need a permit then, right?
Right.
My understanding. So you didn't need a
So there
permit for
was-
that.
Hmm.
So then the violation besides, I guess, the financial penalties associated with that also entails Stan, just talk, not Stan, Mark, talk about the requirement to sort of remedy the situation, shore up the shoreline, revegetate it, that kind of a thing. What is,
So that's
what-
what we,
because that's associated, that's the penalty of this violation, if it were to be.
correct, and that's all we were asking for is that they revegetate the area that had been overly cut and had been violated. So by going and
So
the revegetation requirements are listed out in 11.6.20. It basically spells out what the revegetation is. We're not looking to fine them. We're
Yeah.
not looking to, go that route. Our whole thing is that it just needs to be revegetated. As I had indicated in the notice of violation, we just need a revegetation plan. What is he going to do? Does it meet the revegetation plan in the shoreline, in the land use ordinance? And if it does, we're good. We're done. So
And all of these photos, this photo of this structure, whether it was an outhouse or not, a privy, that's all,
I sent them a notice back then that I found it on a neighboring lot and that was no longer their issue. So that whole case had been dropped. So
okay, so that's not an
yeah,
issue.
it's never an issue.
Can I just say one thing about vegetation? It's a gravel pit. It's very difficult to grow a tree in a gravel pit. That's why there's no vegetation that's grown because it's solid gravel. It may sound like an easy thing to do to replant, but I mean, what was cut down was thorn bushes and, it's not an easy task.
Well, I think nature revegetates itself when you remove things automatically on default.
Yeah, it would try to, but that,
so-
that gravel pit hasn't
Yeah,
really,
it'll tell you the quality of your soil based on what plants you have available.
yeah.
That 75-foot setback, that was all thorn bushes. That was no trees in that part.
But it was vegetation.
It was vegetation. We never.
And nothing was touched in it.
Yeah.
We didn't touch it.
And these pictures are fairly current pictures from this autumn of the property. If I can see that, the date on that.
Yes, yes. That was, I went down, and actually walked the property and those are the photos I took. And in
Quite
one, you can
gravelly.
see where there's little to no vegetation now, right up until within 30 feet of the high water mark. And, again, looking at the pictures, I can only go by the pictures that I was looking at from Google Earth. And it's green. And in the photos that we're looking at now, it's not. And even the photo that was submitted by them just a few months ago, you can say it's clear. It's clear cut.
See those
So-
colored Google pictures again.
Yep.
Look at the 2020,
That one
you look
and-
at 2024. They'll say that the minimum of 75 feet of green vegetation, if you look at the summertime, you can't take a winter photo. I mean, winter photo's not a.
Right. It goes-
I have
Yeah.
smaller.
You see green on the,
that's
on the,
the
at least 75 feet back.
Yeah.
Well, I mean, so,
Treated soil.
on this picture from 2018,
That's
And
75
then
buffer there.
The latest picture was taken actually even in 24,
To try to.
the original of this.
You'd have to
Um,
fill in there.
Yeah.
this distance here
Mhm.
to, to,
Hmm.
to like where, you know, that becomes gravelly
It's at least half of the 250.
is, you're saying is less than the 100 that it's required to
He's saying
be?
it's 30 feet.
Correct. And if you
That's
take a
30 feet.
look, again, what I got to go by is, and I'd rather not sit here and,
Well,
but if you start looking at these photos
Yeah, but
here,
I-
you
yeah, I
can
don't-
see
yeah, but
there's
it-
one tree and then there's
Yeah,
nothing.
but
So-
what I can't tell from any of these pictures
Mhm.
is where the water is. You know what I mean? I can't see where the river is here.
You can see the river's edge. right
I know,
there.
but not from these pictures.
Right.
So the only sort of visual that I have of the violation
Mhm.
is from 2018.
Well, it's
Or
important.
even the current pictures, but you know, we're talking about something that happened
Mhm.
12 years ago. So this, we think it happened between here and here.
Mhm.
So this distance here, I mean, you've measured this as 250, but from here to here is what? I mean,
it's at least half of it.
It's
If you
half of
just take a ruler, and I'm not being critical at
But you
all.
can't take a winter photo and look at it because it's different.
And-
But
and-
this wasn't, this
so
was,
that's all. I guess those are my only questions at this point.
Yeah,
the shoreland zone, again, it doesn't dictate that you, as far as tree removal or vegetation removal, that it's only within that 100-foot area. Again, you've got 250 feet and you can only have certain amount of vegetation that's removed. So
Right.
once again, even if it's outside of that 100-foot area, we're still talking about a violation.
Right, well, that's why I was going over the other parts of the land ordinance just before to see what the violation consisted of. So it's the 100 feet that the town is defining. And is it also then 11.6.17.2.2, which is no cleared opening greater than 250 square feet?
That's correct. That's part of the
Because
second,
I have to go by right now of everything that was submitted in front of me, besides the dates of what happened when, is basically these two sort of photographs. And, you know, knowing that 250 square feet in within a canopied wooded area is only an area of like 15 by 16 foot. Although I understand that if you have a building permit and you're building a house that's,
So that's on page 1114. I don't know if you have your
no, I don't have a.
11.6.173 talks about. This section right here will give you not more than 40% of the lot, not over 10,000 square feet of a building envelope.
Right, and so, I mean. I guess I'm just gonna ask the question then, so has the town determined that the setback is more than, less than 100 feet? The 40% limitation has been violated.
yes, because that's why I sent the notice of violation. The case number 191, the notice of violations that were included in that were 11.6.17, 11.6.17.2, 11.6.17.22, 2.2, and 11.6.17, 2.3.
Okay. All right. Thank you, Mark.
And again, we're not looking for violations as far as monetary. We're just looking for the property to be put back, to, revegetate so that it can be back to its natural state and protecting the river.
Right, and on that point, we have just a 2014 Google Earth image that goes back to 2014, and then we have like testimony today describing gravel pits and bamboo.
Model dumps.
Dumps.
Yeah, I mean, you can drive down there now and look at it. Like I said, it hasn't been totally put back to the way it was before. It was
a dump,
ravaged, yeah, I mean,
but it's, yeah,
I mean,
progress has been made until
Yeah.
really now.
and I don't know what you're talking about for revegetation. I mean, it's not an easy task to grow trees or shrubs even in a gravel pit. And
Yeah, let's let.
It's been
let's let
12
him
years
finish.
and hasn't eroded.
this hasn't eroded, there's no erosion there. You might, you can go down and look at it.
And again, the purpose for removing the vegetation and the trees that you did back then was for what purpose
was to-
again?
To prepare a building site, prepare an area for a septic. And I was told by Stan that if I improved it beyond, if I improved it to the point where it was ready to build, suppose I drilled a well, if I put power in and a septic, it would be considered an improved lot. And he said, now your taxes are gonna go up because the valuation will go up, it will be assessed higher. So don't get to that point until you're ready to build. So I didn't, I got to the point where I put the road in. So there's access. Don had the idea of putting a power pole up for the power line. About 300 feet from CMP's entrance, which I asked if I needed a permit for that. No, there's no permit required for that. So there's a bare pole standing up ready for the power to come in. Then I was gonna go underground. Stan asked me if I was gonna go underground with the power. I said, probably, but wasn't gonna happen right away. Didn't have the money to do it. And so I did the best I could, cleaned up what was, basically a hazard. I mean, my dog got severely cut on it, and I did what I could with what I had. And and I still, like, if I go drill a well now, was it gonna be contaminated? I mean, like I said, the town was dumping their garbage there. And when I bought it, I didn't know that, so I have enough problems without worrying about planting.
Well, I was gonna ask whether you had anybody ever take a look at that.
Well, I need
Property
to,
for
I need
that
to have,
purpose.
once the well is drilled, I mean, we're talking, what, $5,000 to $10,000 for a drill, and then we'll have it tested to find out either it's good or it's not good. That's why I didn't use any chemicals on the bamboo patch, I want, it's not I'm pretty sure there's contamination there, because who knows what was dumped. I mean, there were empty oil cans, there were oil barrels, there was, do I call the DEP? What am I supposed to do?
But you had also said that there was a road, a rudimentary road into the area.
Just the right of way coming in to service the different lots, but there was no extension.
Into the
No.
area where you cleared
No.
vegetation.
Don built a road, I would say it was probably, well, it's almost the length of the property, so, I mean, it was a lot of work. And, I mean, he did a good job, he made it accessible and did everything you could imagine. I mean, couldn't do a better job, so. But it took time and it wasn't cheap, and
The code enforcement officer was on site a dozen years ago, taking care of it. Now, let's let, the.
Yeah, do we have more presentation of?
Yeah, the only other thing I got is we've got no correspondence whatsoever. I have nothing to go by that shows one way or another Stan had any conversations, written down, email notices. There's nothing. I did a search. I tried to find stuff. There's nothing. Nothing's been presented that's in writing. So we'll never know. But what we're getting at, if I can finish, what we're getting at is we're basically saying that Stan Waltz ignored the codes and told them they were perfectly fine to not go by what the codes are. And I find it extremely unlikely that our code enforcement officer would have said, that's fine. I'm not saying that anybody lied or anything else. I know how it happens. I've said stuff before to people and it gets misinterpreted into something else. It happens. But I do not believe with an ounce of my being that Stan Waltz would have allowed a violation of the shoreline zone.
Okay.
Yeah.
Well, you wanted to have a rebuttal?
Just take me 2 minutes.
Yep.
So we have we have a notice of violation for a violation that wasn't even on the property. We have a new code enforcement officer who says there's no evidence of the fact that Stan Waltz was on site. We have two people who testified today that Stan Waltz was on site and that Tom Daggett visited him here. I mean, that's why they're here, is to provide testimony. And if you don't find them believable, that's fine. If you think that the ordinances that were in place in 2014 were violated based upon these photographs that there's been no actual measurements taken. These are Google Earth photographs, and I disagree with the code enforcement officer's statement about the sections that he referenced and that there have been violations there. This guy improved a lot 12 years ago. That was a dump, and the fact that we're here tonight is incredibly frustrating for him, for me, and perhaps for others. I don't know, but we're not here to say that anything that was done wrong on that property. Stan Waltz wouldn't have said you can violate an ordinance. He didn't. No ordinance was violated. He said you can do this. It's not a violation of the ordinance because it wasn't. And the fact that the current code enforcement officer in his new profession doesn't believe it. I mean, I'm going to leave it at that. It's been a frustrating evening, frustrating experience. We hope that this is the end of it. If it's not, we'll continue on. Thank you for your time.
Okay.
Can I ask,
Yep, yep.
also in the original appeal, you also, I mean, it was my understanding that there was a request that we hear this. And in order for you to proceed then to
Well,
further, to
I'll be happy to explain that.
to appeal to the
Well,
Lincoln County.
well, I don't think,
I thought that was the purpose of today, to get through this. I didn't know whether you considered this an administrative session today, so you could move
my
on.
position all along has been that any violation, any interpretation of the ordinance by the code enforcement officer, and this is a Maine law court case,
Mhm.
says that any interpretation of an ordinance by the code enforcement officer that impacts a landowner has to be appealed to the town's Board of Appeals. Now, the town has multiple ordinances that aren't all in sync, and that's not unusual. Multiple towns have municipalities have ordinances that have different provisions for appeals based upon different types of appeal. But in any event, it has to go through the town first, so administrative remedies can be exhausted.
Mhm.
Now, I'm certainly not in any of my correspondence suggesting that we're just coming here so that we can go on to the Superior Court. My expectation is that when more eyes are on this, that reasonable minds will see the logic of this situation. 12 years ago, a court is not going to allow for a statutory, an alleged violation of an ordinance that took place a dozen years ago to be enforced. It would create an incredibly poor precedent that's not sustainable. It's not, you can't operate that way. And I want to be clear, just like we don't accept the assertion that section 11.6.17.1 or 2 or 3, that any of them were violated even back then. The ordinance that we're referencing, by the way, if I'm not mistaken, is the current ordinance, which is not the ordinance that was in place back then. And I'll just leave it at that. I don't expect that this board will think that it's reasonable to assert a violation based upon these circumstances when the work was done. I mean, this testimony is clear that it was done with the approval and knowledge of the code enforcement officer at the time. And to go 12 years later and say, well, no, we don't believe you. And even though we don't have measurements, we're gonna go back 12 years and fine you and tell you have to revegetate this. And you can say that we're not looking to fine you. The schedule of fines was sent along as part of the program, and it was never indicated to me in any way, shape, or form that there would be no fines. And so we're hearing that for the first time tonight. You know, planting a couple trees in this hard, I mean, it's rock hard soil. Yeah, that sounds like something we can try, but then of course you're gonna have the code enforcement officer coming down and check, see if that growth is taking root. Then you have an ongoing, relationship that already is a little bit strained. So we're not excited about that idea, but interested in hearing the board's opinion and open to any more questions. Thank you.
Okay, I guess we gotta clarify what it is we're gonna be voting on here. Because it's kind of hard to carry a vote when we're unclear as far as, are we gonna be voting for, are we voting to have them get a permit for something that was done in the past? Or are we voting to determine whether or not there was a violation of the town's ordinance? So like, I'm trying to figure out like, what,
Yeah. In part, I think you can say that you think that it's reasonable to find a violation for activity that was 12 years ago. Or you can say that you don't think that it's reasonable. You can also say that even if it is reasonable to try to enforce an ordinance from 12 years ago, you don't think that under these circumstances, given that the testimony you've heard with regard to the interaction with the code enforcement officer, that you don't think it's reasonable.
Well,
Yeah.
we used the internet to find some of the evidence here. So I used the internet myself previously to look up what the statutes of limitations are in other places other than this town. And the average is between 1 and 6 years. Massachusetts, which used to be part of that state once, their old common law stuff, even them is a 10-year limitation on a look back. When we're way back in that time at this point. But we currently don't have that ordinance on the books, which I guess is why we're here.
And just by way of background, a regular 6 years is the statute of limitations for all other civil actions.
Yeah.
So court, this ordinance doesn't have a statute of limitations, but courts certainly have guidelines. 6 years is the maximum.
All right. Do you have any questions or recommendations or?
I don't think it's possible to compromise here.
I don't want to say that, like, I never like to be the person who says I'm not willing to compromise whatsoever. We've been put in a pretty difficult position. And haven't really heard from the code enforcement officer that there was anything other than, the fine and the revegetation. Now, I mean, I guess it can be discussed. I honestly think that it's such a clear-cut thing that it doesn't make any sense to me, but I'm willing to discuss it with my client and see what he thinks. Unless the board has a clear-cut decision that,
Can you speak up, please, counsel?
Yeah.
Yeah, I apologize. I'm not willing to say that my client is completely unwilling to compromise because it's just not how I like to operate. But I think this is so clear cut based upon that it doesn't make a lot of sense. If I hear some kind of a proposal about, we'd like you to plant some shrubs and we're not gonna, make a good faith effort to plant some shrubs, but we're not gonna keep on coming down every year because it's gonna be very difficult to make them grow. And usually on those consent orders or those type of agreements, there's some type of provision about making sure that the plants take root. And this is just such a terrible spot for that historically, that I don't want to put them in a position where code enforcement officers coming down and make sure these shrubs are growing.
Well, I mean, you plant something, you never know whether they're gonna be viable so many years out. I
Right.
think there are some guidelines around that within the ordinance about,
There are, and that's,
planting things that you think have a chance of
Mhm.
taking root and surviving for 5 years.
and all of those, respectfully, all of those are assuming that there's been a violation of some sort, which again, we firmly believe that there hasn't. And the equitable solution to this, which equitable estoppel will dictate, and a judge would agree, you cannot go back that far and hold someone responsible, especially under these circumstances. If there's a proposal, we're certainly willing to listen to it.
Can I ask a question about that? I mean, about the statute of limitations for those that know our code inside and out. do we not have any language in here that talks about there not being a statute of limitation? Is it somewhere in the ordinance that?
To my knowledge, it's not in the ordinance. Working with the DEP, they indicate this shoreline zoning has been around 53 years. It's the exact same wording. Back then, 250 square feet unless it's a building envelope. And if there's a violation of an opening, it needs to come back in with a canopy.
And
if-
the issue of.
Even if it took place 30 years ago, they're gonna
and the
require.
setback requirements of 75 or 100. And then
It
this.
started out at 75, then they went to 100.
And this issue about the pond status and the difference between the, what we consider the Madomic versus the state.
We have our own.
And it's a
map.
higher standard than the states. Okay, I get that.
We have zoned this limited residential, which is 100-foot setback for building. But it does talk about you can have the 75-foot buffer and leave place the lawn. I believe Stan explained that
Right.
and I understand what he's saying there.
And then
Well-
you ironically go back, way back when on the card and you see that there was something that specified 160-foot setback.
That was on the subdivision approval. It's interesting, if you look at the map, it showed the old dump on lot 3. It didn't show the old dump on lot 2, but obviously it was on both.
Yeah.
So that was just going back to the subdivision.
So I think the question we've been asking is, first, do we have jurisdiction to hear this? And council has attempted to address that in his letter, in cited a case. It's still, I'm not convinced that he's correct, although I understand and I've read the case and I've read the various statutory provisions. I think you can read them one way, you can read them the other. So I think that's one open issue if we have jurisdiction in the first place, because it's not, the ordinance itself does not specifically grant us authority to review this matter. It's only in connection with permits, the issuance of permits. And it does not give us the ordinance itself. Now, I'm just speaking of the ordinance. The ordinance does not give us authority to review this particular matters expressly. The case that's cited tries to say, and does say, in the case, in the York case that he cited, so the language says that the Board of Appeals should look at these things, or can look at these things, or is required to look at these things. But if you read it together with the rest of the language in the case that was cited and in the statute that was cited, that he cited, you can, if you read it together to make it sense, then we still don't have authority. If you read it the other way, we do. So that's the first open question. I think the other question that we're being asked is, has the CEO acted reasonably? Is the CEO, with all the citations and notices and so forth, has he abused his authority? Has he acted unreasonably? Is there something wrong with his decision? And by the way, the burden of proof is on the appellant, as you know, by the applicant, right? So the assumption is that the CEO has acted reasonably in exercise of his authority, and it's the job of counsel on behalf of his client to meet the burden of proof that that's not the case. So I think, though, to narrow down the questions, the two are: do we have jurisdiction? And we can make a decision on that. We could be right or wrong on that. And then we can make a decision on, have they met, has the plaintiff, or in this case, the appellant, the applicant, met its burden of proof that the CEO acted unreasonably in issuing the various notices and citations that he's done. So, if counsel wants us to reach that decision without having a conversation and a discussion of negotiation with the CEO, that's okay, we can do that. But it might be useful for them to see if they can work out a deal, in my view.
I think that's a reasonable conclusion.
I think that's right.
Could we ask for some perhaps to table the discussion
Sure.
for 1 week for us to confer with the code enforcement officer and see if we can arrive at a reasonable compromise?
That'd be okay with me. Mr. Chair, what do you say and the rest of the members?
We can put that to a vote, which would, I would support and to further the matter for a period of, do you think 1 week is a reasonable time for you to have those discussions in?
So you'll forgive me, I just recalled that I will be out of town next week. I just, as soon as I said it, I said, oh boy. I would ask for 2 weeks, Ben, because I'll be back the following week.
All right.
And when do you meet
Well,
next?
I think we technically meet on a monthly basis, right? So like,
Maybe we just say
Well-
prior, like a week.
Yeah, we can
prior.
we can do it next month if you want. If you want a month's time, it's okay too.
I think that would probably make the most sense, that we just have between now and next month's meeting, try to come up with a solution.
okay, so I'll favor that as I can make a motion that we meet again in 1 month and allow the parties to come to an agreement. And if they're unable to reach an agreement, then we'll be willing to convene to hear this out further.
Second.
Okay, I'll show of hands in favor of that motion.
Aye.
Unanimous. So we'll see you in next month.
Thanks again for your time.
Great. Thank you all.
Yes.
Okay,
This is the one that.
I have a lot of papers now.
So, but
Yeah, and then when you start shuffling those.
But I did make a
they
file.
become a mess.
I put the, love to see it.